All right. Good afternoon, everyone. If you are in Europe, or otherwise good morning or good evening, or pick your time zone appropriate greeting. I'm Michaela Hailbronner, and I have the pleasure to welcome you all to this wonderful session with our current Openness co-president Lorenzo Casini and our incoming co-president Marta Cartabia. Quickly about the procedure, we'll start with Lorenzo interviewing Marta for about half an hour, and then we'll open up the sessions to questions from you. And I'll encourage you to use the questions and answers feature here on Zoom, or alternatively, you can also send questions over the chat. I'll try and keep an eye on both. And finally, before I hand over to Lorenzo, I wanted to say a quick word of thanks, at least, to Fred Zaumseil, who is kind of ICON's technological and social media brains and heart, and is responsible, has had the idea both for this event today, which is wonderful, I think, and also did all the legwork of organizing it. So thank you very much, Fred. And I'll hand over to you, Lorenzo.
Thank you, Michaela. Of course, thanks, Fred. And many thanks to Marta for accepting our invitation to be here with us. Everybody knows Marta is a professor of constitutional law at the Bocconi University, Milan. She was judge of the Constitutional Court of Italy between 2011 and 2020. When she was appointed, she was one of the youngest judges ever, and only the third woman in history of the court. She was vice president of the court from 2014 to December 2019, and then she was president of the court from December 2019 to last September. She was the first woman to hold the office of president of the Constitutional Court of Italy. She was born in San Giorgio sul Legnano, near Milan. So let's start with an easy question. So do you often go back to San Giorgio or not?
Not really, Lorenzo. This is very strange. But I keep a wonderful memory of San Giorgio because my grandmother lived there, and I go back in my mind. I have wonderful memories of the summertime spent in the countryside with my grandmother and my cousins, but not that often physically.
Okay, so we will try to focus, as we promised to our participants to this webinar and this interview, to how to build trust in institutions. Now, I want to start from this quote. The idea of giving 9 unelected, tenured for life lawyers in black robes the power to strike down laws passed by a majority of people's representatives doesn't sound very democratic. Now, this is Barack Obama in his last book describing the US Supreme Court. Of course, we can imagine how then Obama tried to develop his point, but how would you respond to this?
Well, this is a classical objection to judicial review. It has to do, for the scholars, with the counter-majoritarian difficulty, or if you want, with the debate that took place in Europe between Kelsen and Schmidt about the political or judicial nature of the guardian of the Constitution. Well, I will respond to this question to ordinary people, taking into consideration the issue of what is democracy. Is it just a matter of decision taken by elected people, by people that are the representatives, so just a procedural notion of democracy, or does democracy imply also the protection of some values, principles, like, for example, I don't know, freedom of expression? What is a democracy without freedom of expression? So I think that when constitutional courts were built all over Europe, and even before Europe, in the United States, the judicial review of legislation given to the Supreme Court and ordinary judges, the idea was to protect a thick notion of democracy So also the condition that allows for a genuine democratic procedure to take place. But and so my first answer will be about that. Democracy is richer than simple procedural rules. But I have to add another question, another remark, and it is that in recent times, constitutional courts are also called often to protect the genuine democratic rules. When I was at the Constitutional Court in Italy, two cases concerned electoral legislation, the electoral system, and the court was invited to strike down those parts of the electoral system that were not consistent with the principle of the Constitution. And in other cases also, we were asked to overview the correctness of the let's say the due legislative process inside the parliament. So courts protect the values that are necessary to have a rich notion of democracy, but also the procedure as such.
Yes, so when you were talking of scholars or people who compare the courts as the referees of the democratic pitch, so that basically you have you need someone at some point to verify the respect of the rule. So, and this is part of the democracy, as you rightly mentioned. Coming to what was your experience at the court in your report of the activities of the court that you delivered last April, you wrote expressly about an open court. Now, what did you mean exactly by open?
Well, there are many different facets of openness. The most relevant one I referred to was the approval of some reform in the rules of procedure of the Constitutional Court. As soon as I was elected, the court took the decision to introduce the amicus curiae, which was something that was not in the Italian tradition, and also the possibility of hearings for experts in matters other than law. And this was, let's say, the most relevant opening up of the process to the contribution that can be brought to the court by civil society, other expertise, in order to have a richer process in front of the Constitutional Court itself.
So, but was the amicus curiae brief ever used during that?
Immediately, we had immediately a huge number of requests, even before the reform could take place. There was a very lively reaction, and I can mention just one case, for example. The court is dealing with a difficult case concerning defamation, the custodial criminal penalties for defamation. And for example, in that case, the Association of Journalists asked for intervention in that moment. So this was an opening up, but there are also many others that I know that are taking place in the at present in the court. We will see the fruit of this reform with some months of delay, because indeed it was applied only to new cases in the Constitutional Court. The change was in January 2020, and we will see how many of them will be accepted in this next months.
I now want to, perhaps ask you a bit more difficult question that goes to the Italian Constitutional Court directly. So, do you think that our court, the Italian Constitutional Court, might suffer a lack of legitimacy?
Well, the reform was not meant to fix any problem of legitimacy. I don't think that the legitimacy of a court is based on the participation of the amicus curiae or the expert. This was on a different plan. I think that the legitimacy of the court depends on the authority of its member, of the good and strong legal reasonings of the court itself. If we use the usual distinction between input and output legitimacy, I think that a court legitimacy is much more based on the output rather than in the input legitimacy.
And so you didn't witness any reaction on the idea that this openness to experts might be a sort of recognition of some limit of the court in terms of expertise, in terms of iura novit curia?
There is no limit to improvement, so we can always learn more from.
I mean, as soon as the court decides. So
exactly, exactly. No, I think let me add one remark on this point. The reason why we decided that the internal debate was, on the one hand, based on the fact that an increasing number of cases implies scientific and technical debates. For example, I was the rapporteur for a case concerning the obligation of vaccination 2 years ago. It was long before the actual debate on the imposing vaccination and so on and so forth. And we had to know and to handle with medical and other stuff that is not legal. We needed to go, for example, to the Health, the World Organization and other experts on the point in order to understand whether or not there was sufficient basis to impose this possibility, the vaccination on people. On the other hand, we were addressed as to the amicus curiae. The Constitutional Court was regularly addressed by groups of people, association, NGOs, or other subjects in society that sent us informally papers, brief written contribution, but we didn't have the procedural instrument to consider them as part of the formal legal documents in the Constitutional Court. So it was a reason of transparency in order to open up to everybody the possibility to bring information or remarks, comments to relevant cases, and also to let people know what are the brief and the subject in society that wanted to say a word on especially debated issues that are interesting for all the society as such.
I do agree, and as far as I remember, what happened in the court that before this reform, the justices and the clerks were used to consult experts in order to have an idea, more technical aspects. So this was a way to make the process more transparent. So
exactly,
that for sure. Now, one important point in building trust is, of course, the institution is the perception by the public. I want to read you 2 lines. Very few people on the street looking at the presidential motorcade. The Constitution and the Constitutional Court, unfortunately, are not concepts and institutions which thrill our careless contemporary citizens. Now, this is taken from the papers commenting the Italian Constitutional Court first hearing in April 1956. Now, is this still true?
Yes, I think that people do not know much about Constitutional Court in Italy. Whereas in other countries, Constitutional Court are very popular, people are familiar with the institution. generally speaking, average people do not have a clear idea of what a constitutional court is. They may mismatch the constitutional court and Supreme Court or other courts. From time to time, there is a debate when a specific decision draws the attention of the public on the merits on the case. But even the people that the judges, the justices of the Constitutional Court are not very popular, they are not very visible. This is different in Italy than it is in other countries like the United States, for example. That's why when I speak of openness, I spoke of openness in my report, I wanted also to refer to a number of activities that the court has taken in the last couple of years, 2 or 3 years, in order to make herself understood and known by people, speaking to people. Once I was addressed by a question from an American scholar. He said, to whom the court speak to? And it was a shocking question, because when we read the decisions, usually we can have in mind, when we write the decision, we can have in mind the parties, the lawyers, the judges, the scholars, maybe some political institution, but not the people. And we take decision in the name of the people. So that's why in the past 2-3 years, the court has made a big effort in order to make herself understood by people.
So basically, do you think that in Italy, the Constitutional Court will not pass the taxi driver test?
I don't know, maybe very soon. If they go on in the same vein that the court has taken in the past 2-3 years, it might pass the taxi driver test as well. I
can tell you my experience that I have a half experience, so that I had to use Piazza del Quirinale and not Constitutional Court, otherwise exactly. I didn't know how to go. So how does the Italian court interact with the public then?
Now there was an important effort. First of all, the court has, let's say, reinforced the communication office, the press office with professional journalists, and the court is much more regular in issuing press releases, not only on the big decision, the 2-3 big cases that happens in a year, but also on, let's say, smaller cases, but cases that affect everyday life of people, because that was the point missing. The Italian Constitutional Court has always had a relevant, important press office, but the press office worked on selected cases, and this appointment once per year, a press conference with journalists. But in my view, what made the Constitutional Court so distant, so obscure for ordinary people was that people didn't know how many things in their everyday life has been changed by the Constitutional Court. And for this reason, for example, I have accepted to work for a TV program, a long interview of 6 episodes telling the story of the changes in women's rights through the history and the collection of decision of the Constitutional Court. And when I prepared this material, I found out that there are so many things that affected the women's life thanks to small, maybe unknown decision of the Constitutional Court since the beginning. So
you think that these initiatives contributed to increase people awareness about?
I very much hope so. I very much hope so. I'm in favor of this this possibility of using media. For example, I made reference to this initiative by the RAI television, but there are also the podcasts that the court has started to post almost every week in order really to have people, to give people the instrument to understand what the court does.
Yeah, it happens to me as well to listen the podcast that on Instagram that you can
exactly
that you can find from the court. Also, other initiatives that were taken were the judges of the court visiting schools and prisons, right? So can you tell us more about that?
Yes, this was pre-COVID. That was the possibility. This was what we called the journey in Italy, using the Goethe famous title of book. We moved around. The judges decided to visit, first of all, schools once per year. Each judge went in different region, visiting a couple of schools in one day, explaining what the constitutional court does, what is the most relevant decision in that moment, or maybe taking one of the principles of the Constitution in order to nurture the civic awareness of students and professors. And that was fantastic because the visit of the justices were always well prepared by the schools, so that students and teachers alike spend time in reading and preparing questions, and there were also follows up. So it was really a wonderful movement around the Constitution. And the program was to go on a regular basis with this visit, but then, the COVID stopped us from this point of view. And before the COVID, the lockdown, we also took a very courageous step. It was visiting prisons. And that was even more striking for us and for everybody. The result of this visit to prisons, in my view, was that the judges, the court, going in the most distant places in the society, has had an effect of drawing attention on the court also from all the rest of society. So it was visiting prisons, but we reached everybody, not only people living in prison, thanks to this journey and to the documentary, the movie that was made always by the state TV RAI on these visits as well.
I found those initiatives very important for the reason also that you mentioned at the beginning in terms of spreading awareness of democracy and how this should be known from everybody. But going back to the relationship between the court and democracy, since there are plenty of scholars, positions about the crisis of democracy, so how do you think that this would affect the Constitutional Court? So if there is a crisis of democracy?
Well, I would say that, let me answer with a phrase by St. Paul: if one part suffers, all the body suffers. If democracy suffers, also all the institutions are in a way affected, and not in a good way. In my view, one of the role of Constitutional Court is also to preserve the proper functioning of the democratic process. We can go back to the beginning to this point. So the courts are all very often perceived as counter actors, as if they were they had a veto power on the democratic process, but in fact they are also there to boost, to support the democratic process. Indeed, with different roles, there is no overlap of mission and tasks of the Parliament and the Constitutional Court, but there is a mutual reinforcement of these two sets of institutions that we can take in mind. In my view, what is happening, and we have to be very, very careful about that, is that oftentimes when an issue, an open issue in society does not receive an answer, regulation within the democratic political institution, very often they are moved to courts. This is a delicate balance. Courts can do their job, have to do their job when there is a violation of constitutional principles, but at the same time have to find a way not to take over also the mission of parliaments and chambers. And in Italy, we are experimenting some new forms and remedies in order to have the court as a protagonist of the political debate or the public debate, but at the same time leaving and giving a leeway, the first say to the political institutions as well.
So in order to trust an institution, of course, its language is important, no?
Yeah.
I want to read you 2 lines by Ruth Bader Ginsburg saying, on the whole, we think of our consumers, other judges, lawyers, the public. The law that the Supreme Court establishes is the law that they must live by. So, all things considered, it's better to have it clearer than confusing. So, do you think that the language of the Italian court's decision is plain enough?
To be read by people that have no legal skills, I don't think so. I have to say very honest. I have to say, be very honest. It's difficult for those who are not initiated to the legal language to read an opinion of the court. That's why the opinions of the court, in my view, are addressed, as I told you before, to lawyers, judges, European judges, scholars, students, but always with some legal skills. That's why I think it is so important that court, and it's not only an Italian experience, find ways to convene the content and the gist of the decision also to the public by means, for example, of press releases or explanation by the Chief Justice. I remember, for example, Brenda Hale, when with the very relevant decision concerning the sovereignty of the Parliament. She announced the decision in front of the press, and it was very important because it was so relevant for all the public debate in not only in the UK but in Europe. It is important that people can understand, and I think that there is way to translate the technical decision into understandable messages to the public.
So since I want to leave time for the Q&A, now I'm going to a final set of question where you can answer if you wish, even with a yes or no, but I mean, so I'm sure that you fortunately will tell us something more. First question, the famous quote, "We are not final because we are infallible, but we are infallible only because we are final," by Robert Jackson. So is this what you experienced?
Yes, Indeed. Yes, there are, yes, it's true. There are cases. The first thing that you learn when you arrive on the bench is that there is no just one right question and one one right answer and one wrong answer to one constitutional question. There are many different answers, more or less right and wrong. So a case may be wrong. I disagreed very much in some cases, but they are final and I stick to the decision of the court. A different thing is about principle and doctrines and legal framework in which a case is decided. Principles and doctrines and legal framework develop, and there is an ongoing debate that involves not only the Constitutional Court but other courts and the Parliament and the civil society. So the case is final. The legal framework can go on.
And then a question that I think people would kill me if I don't ask you, that is, how do you feel being the first woman to hold the office of the President of the Constitutional Court?
I felt honored and I felt very much the responsibility, because I realized that it was an historical step in Italy. Although I have to say it came pretty, let's say, it was not surprise from inside. It was a natural evolution of a previous work, but nevertheless, I felt the responsibility of this, and I realized immediately when the day of my election, more or less 1 year ago, there was this great attention from the media and great visibility, because it was emblematic not only for me, but for all the women that before me and hopefully after me has worked so much in order to have a more balanced parity and representation of women.
Well, somehow you open the path, no? If we see what happened in the United States.
I very much hope that many others can follow in the same way and in the same path that was that happened to me to open just, you know, by chance.
We all very, very much hope to. And your most difficult challenge during your mandate?
Well, it was during my presidency, it was the COVID, because after a few months, I had a wonderful program for those months full of international relations, many innovation to conclude, to achieve, and so on. And then after 2-3 months, the pandemic broke out and all the plans were taken upside down. Yeah. But it was also, as usual, a great opportunity also for a lot of innovation in the Constitutional Court.
And so what is your most beautiful memory?
Well, many beautiful memories from these 9 years. Probably I will never forget the day when, after 3 years I was in the court, Judge Sergio Mattarella was elected as the President of the Republic. He was one of us, and so all of us felt honored of this choice made by the Parliament. We were all very, very proud of that.
So going to towards the end, a question that I'm sure that many people would ask you, and is still personal, but why did you become an academic?
The fault is of my professors. They were so fascinating, especially some of the professors that I met during my PhD and the last part of my university studies that, you know, it's by imitation. I wanted to become as fascinating as they were, and so it's their fault. I didn't imagine to become an academic.
But why law?
I don't know. I still don't know, because there were no tradition in my family about legal studies. The thing that was that probably I've asked myself many times this question. The thing that probably can explain my choice is that I had a strong feeling of what is just and mainly what is unjust, and I suffered so much. You know, even the small thing that happens in schools, in the normal relations. And so I didn't know what exactly meant to become a lawyer, but I wanted to you know, go deeper in this field of justice because of this, let's say, personal need to better understand this dimension of life.
So my very last question, because before giving the floor to Michaela for moderating the Q&A part, so if you should explain to your kids or to a child why the Constitutional Court is a fundamental institution, what would you say?
I happened to be invited to explain law, the Constitutional Court, and so on to very different kids of different age. And I realized that all kids have, I will start with something that they know by experience, and they know very well by experience what rules are and what unreasonable rules are. So they clearly understand the importance of rules. They are required all the time in schools, even in family or when they play sports, to respect rules. But they also clearly understand that rules sometimes can be unreasonable, and they are unreasonable when they simply compress our freedom for no purpose, without respect of the person as such. And so I would explain that Constitutional Court are there in order to review the rules and to be sure that all rules are always not unreasonable, or not unreasonable to a level that cannot make sense to have them. I think that this canon of reasonableness, at least in the Italian Constitutional Court, is the meta principle that explain the role of the Constitutional Court in the system.
Thank you very much, Marta. Michaela, I think the floor is yours for.
Yes, thank you, Lorenzo. Thank you very much, Marta, as well. That was very interesting. We already have quite a number of questions in the chat. I don't know, Marta, if you have had an opportunity to look at them yourself. Should I read them out?
Yes, please. Yes, please. I was concentrating on Lorenzo, so I didn't read the chat.
I understand. So maybe I will just read them out, and I'll try and bundle a little, but it's not always possible. So the first question is from Professor Tega, and she's asking whether you might expand a little bit on the themes of your 2016 book, where you've been highlighting a peculiar, although not necessarily exclusively Italian style in constitutional adjudication. Based on your knowledge of Italian and non-Italian scholarship and case law, what are the main features of the style that might recommend it to a broader scientific and professional audience?
Thank you. Thank you. She's referring to the book that I wrote together with some colleagues, Paolo Carrozza, Andrea Simoncini, Vittoria Barsotti. It was a wonderful experience to write the book with all of them. And the idea was writing a book that could explain the Italian experience of constitutional adjudication to a broader public, because there were not so many contributions of the Italian Constitutional Court, and we felt that the Italian experience was a little bit overshadowed by other experience, even if we have something to say in the comparative context. And when in the end we wanted to say, okay, but what is the Italian voice? What is the Italian style of adjudication? After long discussion, we came up with this word, relationality. That was an intuition at that moment, and I expounded it a little bit more, even on an editorial in Icon. I think that in order to understand, along with other classification of constitutional adjudication experience, you know, weak and strong experience, centralized and decentralized, and so on and so forth, you can also have a look of the kind to the kind of relations that a court maintains with other institutions, with other justices, with other judges, with the political actors, with the society. And I think if you wanted to understand what is the contribution, the peculiar feature of a constitutional court, relation with other institution is very, very important. And for example, there was a moment where there was a clear difference, for example, from the German court and the Italian court applying the same doctrine, the doctrine, you know, of the, let's say, the identity review, or the ultra-vires in regard to European legislation. The doctrine is the same. The result was very different because of the type of relationship that the Italian court and the German court decided to have with their counterpart in Europe. So I think that it's very important not only to look at, you know, the powers, the composition, the remedies, and the structure of the procedure, but also the relations. The relation should be one of the elements to be taken into consideration in order to understand what's the real experience of a given institution is.
Thank you very much, Marta. Now, in theory, we have only 12 minutes left. I think we can run a little bit over, but we shouldn't be running over too much. So let me try and bundle a few questions for you that are on sort of related themes. So there's one question about whether there has been any form of a pressure from populist politicians or from the media on the court in order to influence decisions of the court in certain cases. Then there's a question whether you have any advice for a judge in particular, for example, in Eastern Europe, how they should behave in a situation where we're dealing with an illiberal democracy. And then there's a question that is perhaps a little bit related by Stefano Usello, how to sort of deal with a case where an issue is very sensitive or divisive, and how you would approach that as a justice.
Well, to my knowledge, and not certainly in my experience, I've never had any form of pressure by politicians. I cannot speak for other justices, I cannot speak for other experience. This was something that was very surprising for me, because when I was appointed as judge at the Constitutional Court, I expected to, you know, be in a way addressed by some people and so on and so forth. Independence of justices is, in my view, the treasure to be protected at all prices, Independence, impartiality is something that a judge should be proud of. And there are some conditions that allow this independence to be in effect practiced. And for example, I consider that a long-term non-renewable is an essential precondition for independence. But indeed, as the court itself had said, independence is an attitude. The external condition can facilitate this attitude, but in the end, it's a decision up to the judge itself. I think that the most relevant and most important thing to do is not to be worried about future and possible position of responsibility. You are a judge, you are there for a term, you do your job, then it's over. Don't think of what happens next. You go back to your profession and to your work, if you are from the academy, or I don't know what else, if you come from a different position, to the bar, if you come from the bar, to have another possibility without depending on the political life is the most important thing that allows you to be independent if you want. But indeed, I know that sometimes courts are called to decide very sensitive cases, cases that are divisive, cases that can disturb some parts in the political debate. And indeed, you have to know that courts are in a very uncomfortable position because they have to say no to somebody. So some critiques and even some attacks are, you know, in the contract when you decided to become a judge of the Constitutional Court. What has been useful in my experience, it was when for example, in the Italian experience, what is very useful is that we have, you know, an access to the court that always brings some delay between the political debate and the decision of the Constitutional Court, because we have the main access to the court is via incidental procedure. So it always takes some months, sometimes years before deciding cases. And this is very relevant, maybe to manage a little bit with the docket in order to let things slow down, to the debate, you know, to calm down a little bit, gives the court the opportunity to take a more considerate decision without the feeling that you are deciding in favor of this or the other. For example, we had some decision to be taken regarding immigration law that was at a given moment in Italy a very hot politically strong debate about that. But fortunately, the court was involved only some months later, and the decision was very, after all, simple to take because the political debate calmed down. So time is important. And also, I think that I was mentioning at the given moment new remedies that the court experimented for hard cases, for example, end-of-life cases, and the one that I mentioned about defamation. And it was a remedy that was inspired by the Canadian court and the UK Supreme Court, giving some time to the Parliament to decide if they wanted to fix the problem before the Constitutional Court. in my view, it was a good way to cooperate also with the political institutions, and indeed, in the end, the court had to decide because cannot leave the case open, but it was after giving, a possibility to the political institution. This also helped, in my view, a bit to render the decision of the court more acceptable, even from those who disagreed.
Yes, that sounds very convincing, and it leads actually, I think, to what is sort of a second complex of question. I probably won't be able to pick up on all of the questions that are being asked, but since you've been talking about preserving the authority of a court, and you've emphasized very much sort of the link to the people and that the court makes itself understood, there are a few questions in that regard. One is more specifically on what you referred to before, in response to Lorenzo's question on your experiences with the outreach that the Italian Constitutional Court has done, in particular in prisons. There's also a few questions, one with regard to access to justice for poor people, whether that is an important sort of component and what can be done in order to ensure that kind of access to justice. And then there's a question in terms of the relationship of the court being accessible and the popularity of the court in comparison to the Colombian Constitutional Court, for example. So maybe you can sort of say a little bit more on that broader theme.
So, well, there are different issues on this. First of all, well, I think that the first step is that people know about the existence of the Constitutional Court, and that the Constitutional Court is a guardian for the right of all people, especially for vulnerable people. And so it's important to continue with this this activity of building awareness of what this institution is. I see that Cesare Pinelli is asking about the role of scholars also in filling this gap. Yes, some type of scholarship can be very helpful if the scholars are not themselves trapped too much in the technicalities, but want to take the role, which is relevant and important in my view, of public intellectual, public figure that take the honor and the responsibility to try to explain what the court does to a general public. That would be really very, very, very important to scholars, to students, and also beyond their institutional activity. As to access to the court, I would say that constitutional court process do not have costs, so they are accessible from the economic point of view to everybody. They are free of charge, but the problem, in my view, is that we do not have direct complaint. So for people that want to reach the court, they are required always to have an intermediate step. They have to address an ordinary court, administrative, civil, criminal, whatever. And then it is the ordinary judge that addresses the court. So there is, let's say, a procedural cost that can feel the court more distant to the small ordinary problems of the constitutional of the people. I'm not making the case for direct complaint in Italy, but indeed there is this intermediate step that can discourage at least some of the people to get to the court, and many times the violation of the rights of the very vulnerable is brought in front of the court thanks to the intermediation of some subjects like association, NGOs, or other social groups that can bring the case in front of the Constitutional Court. Are there other questions on this issue, Michaela?
Perhaps not directly on this issue. There's one more specifically, whether you could say a bit more on the remedies, since you just touched again on this.
In the case, in Cappato case, the assisted suicide.
Yeah, exactly.
In this case, the court decided to postpone the decision 1 year later. In postponing the decision, the court issued an order, let's say a shorter decision than usual, saying the reason why the challenged provision had some elements of unconstitutionality. But since the remedy to this violation of the Constitution required the writing of a new provision of law, the Constitutional Court wanted the Parliament to have the possibility to pass a new law in order to have an updated normative concerning assisted suicide. Unfortunately, the Parliament didn't take this opportunity. The time elapsed with no answer, no reaction from the Parliament. And indeed, the court had to decide and in a way took the place. Is not correct because still is necessary regulation by the Parliament, but at least enumerated the condition and the principle in which assisted suicide cannot be punished in Italy in specific cases. It was a case of a person that after a car accident was completely paralyzed. It was couldn't see, couldn't speak, and suffered from was very much suffering for pain and everything. So the court decided in a way, taking as an example the specific case at issue, but still a new regulation is necessary. But so far the Parliament has not passed any law, issued any law on this point.
Thank you. There's a lot of questions I think we could still ask, but let me perhaps ask one last set of questions and then we'll close with that. So there's a number of questions on judicial dialogue, more particular, both between the European Court of Justice and National Constitutional Court, but there have also been a few questions above in terms of what might constitutional courts do to help each other, in particular where other courts are dealing with a sort of democratic backsliding situation. And perhaps generally, to have me add one question, perhaps generally, how important is what other courts do? And I don't mean now supranational courts. I mean, how important is it what other constitutional courts do? Is this something that matters very much in terms of backing oneself up? Or is this sort of just a nice to have thing, but not something that really matters all that much in the practice of constitutional adjudication?
In my experience, what happens in other legal system has always been very relevant in the Italian experience, even if it is only in recent times that the Italian Constitutional Court explicitly mention the source of inspiration from comparative law, and the court is doing this often and often in recent times. But if you go back even to a very debated decision like those on abortion and so on, you can see in the records of the court that there always have been a comparative section of the research office doing research in other experiences, and the court for sure was aware of what happened in other systems when the court took its decision that was indeed original, different, but having in mind, it's not that the court has to import or to have this kind of transfer of remedies from one court to the other, but it is important to have a source of inspiration, and then the solution can be adapted to the context, but it opens the mind of the court. This is for sure very relevant. I don't see what court, sometimes people speaks about judge as diplomats, as if judges can do something when other courts are in difficult condition. I have not seen that much. It's always very difficult because the courts are not in charge of this mission. But for sure, at least at very, very general level, that can be support as to independence of courts, but never in the merits of specific cases. It's not just for the meetings and the networks of courts are not just entertainment. There are a number of relations that can become very important in many different ways, especially when there is a sort of continuity in the time and the people that meet are always the same. They can really do something to improve the quality of their decision, to have exchange of view, you know, to have conversation. And I remember a number of very, very interesting meetings, especially as to the method, the organization of the court, the general legal doctrine. For example, Italy has imported the test of proportionality that was not there. We used to reason only in terms of reasonableness balancing, but never using proportionality. And that was something that helped a little bit the court to have more reasoned opinions. But in my view, it is very difficult very difficult water for a court can be calmed down by the support of other courts. This is something that is not in the jurisdiction, in the competencies of the court to do.
That sounds very convincing to me. I think as lawyers, we tend to exaggerate, of course, the importance of what we do. I think this brings us to an end. There are still some questions, and I apologize for not asking all the questions, but I don't think we should be running over too much. And so I would just thank Fred, Marta, and Lorenzo at this point. Lorenzo, would you like to still chime in quickly?
Say thank you to all of you, for the participants, and for the questions, and a special thanks to Marta for accepting our invitation.
Thank you for giving me the opportunity to have this wonderful conversation, and thank you to all the people that assisted to this webinar. Thank you very much. Bye, Michaela. Bye, Fred. Bye, Lorenzo. See you.